Court is now ready to deliver its judgment in this matter. The court having been informed that Mr. Vusumuzi Donald Sebolai requires this judgment to be interpreted. Accordingly, Madam Interpreter, you are the officially sworn interpreter of this court. Would you assist us in interpreting the proceedings for the accused? Thank you. For the purposes of the judgment, Mr. Matopo, the accused may remain seated. Thank you. Pair the court. Mr. Vusumuzi Donald Sebolai, the accused, is arraigned on the following charges. Count 1. Murder, read with Section 258 of the Criminal Procedure Act number 51 of 1977, as well as Section 51 of the Criminal Law Amendment Act number 105 of 1977. Count 2. Theft of a motor vehicle, read with Section 250 and 264 of the Criminal Procedure Act 51 of 1977. Alternative to Count 2, contravening the provisions of Section 66, subsection 2, read with Section 89, subsection 1 of the National Road Traffic Act number 93 of 1996, as well as Section 250 of the Criminal Procedure Act number 51 of 1977, which is using a motor vehicle without consent. On count 3, the accused is charged with defeating or obstructing the administration of justice, read with Section 256 of the Criminal Procedure Act 51 of 1977. It is alleged that on 29th of June 2014, the accused unlawfully and intentionally caused the death of Flavia Rachel Tshabalala at or near Block D006, Jabulani Views, Jabulani, Soweto. It is alleged further that on the same date, time and place, the accused unlawfully and intentionally stole a white Fiat Palio with registration number VTP 297GP, which belonged to the deceased. In the alternate, it is alleged that the accused unlawfully and intentionally rode in or drove the said vehicle without the consent of the deceased. It is alleged further that during the period 29 June to 8th July 2014, and at the place mentioned herein above, and at other places in and around Soweto, the accused did unlawfully and with the intent to defeat or obstruct the course of justice committed the following act. In that he destroyed evidence at the crime scene and removed evidential material from the crime scene and or discarded evidential material in a dustbin and or fleeing the crime scene with the aim of foiling the police in their investigation and or to avoid arrest and prosecution. The accused pleaded not guilty to the 3 charges. Safe to state that he had acted in self-defense. No further explanation was provided by the accused in support of his defense. The accused made formal admissions in terms of Section 220 of the Criminal Procedure Act 51 of 1977, hereinafter referred to as the CPA. Briefly concerning the identity of the deceased, that she had died sometime during the night of 28 to 29 June 2014 at Jabulani Views, flat number D006, Jabulani, Soweto, and that the deceased sustained no further injuries from the time her body was discovered on 29 June 2014 and transported from the scene of crime to the government mortuary. And up to the time when Dr. MP Morule, hereinafter referred to as Morule, conducted the post-mortem examination. It is trite that in order to succeed with the prosecution, the state has to discharge the onus to establish the guilt of the accused beyond reasonable doubt. And on the other hand, the accused bears no onus but will be entitled to a discharge if he presents an explanation of innocence which is reasonably, possibly true. This trite legal test is more succinctly and elegantly stated by Nugent J.A. in S. versus Mbuli. The citation is 2003, Volume 1, SACR 97. It's a Supreme Court of Appeal decision, as follows. And I quote, "It is trite that the state bears the onus of establishing the guilt of the appellant beyond a reasonable doubt. And the converse is that he is entitled to be acquitted if there is a reasonable possibility that he might be innocent. In whichever form the test is applied, it must be satisfied upon a consideration of all the evidence. I quote further from the case of Susha, S-U-S-H-A versus S, 2011, JOL 27877, a Supreme Court of Appeal decision. I quote as follows. An accused version can only be rejected if the court is satisfied that it is false beyond reasonable doubt. An accused is entitled to an acquittal if there is a reasonable possibility that his or her version may be true. A court is entitled to test an accused version against the improbabilities. However, an accused version cannot be rejected merely because it is improbable, close quotes. To discharge the onus upon it to prove that the accused committed the crimes charged, the prosecution called the following 12 viva voce witnesses. Constable M.M. Malepi, hereinafter referred to as Malepi, the photographer and official draftsman at the local Criminal Record Center, who attended the scene on the 29th of June 2014. Constable M.M. Malepi na photo He confirmed that he compiled the photo album and sketch plan thereto, and inter alia testified as follows. He observed the deceased lying on the bed in the bedroom as depicted on photo 9 of Exhibit C. Once he removed the blankets that were covering her, he observed that she had no clothing on her upper body. He observed blood on the bedding and in the pubic area of the deceased. He did not observe any damage to the pants of the deceased when he removed same, and further observed a wound on the top of the vagina of the deceased as depicted in photograph 18 of Exhibit C. Upon further investigation, he observed a mop behind the door that appeared to have blood on it. In addition, he observed a knife on the table as more clearly depicted on photograph 42 of Exhibit C. He took swabs of alleged blood stains that he observed on the door frame of the toilet and the fridge. He observed clothing together with a floor mat which appeared to be blood-stained inside the washing machine as depicted on photograph 34 of Exhibit C. He examined the carpet and the floor in the lounge and observed alleged blood on the carpet and stains on the floor. His attention was drawn by members of the community to a refuse bin situated outside the flat, wherein he found a bloodied trouser. He accordingly photographed the trouser together with other points as depicted in the photo album. During cross-examination, it was put to him that the distance from the couch to the bedroom, couch to the kitchen, and couch to the toilet were critical to the defense of the accused. He responded by stating that he did not find anything of importance on the couch, and hence it was not important to take any measurements of the aforementioned points, as it did not form part of the evidence on the scene. He testified that although the distance from the aforementioned couch was small, a person could have escaped to the toilet if that person were attacked whilst at the couch. His observation of the apartment was that it was thoroughly cleaned. He arrived at such conclusion by referring to the trace of blood on the refrigerator, blood on the mop, and that everything was cleaned. He testified that he did not see any signs of a scuffle inside the flat from his investigation and observation of the flat. He was of the view that had the accused been present on the scene at the time when the photographs were taken and pointed out specific points to him, he would definitely have taken such photographs. I pause to mention that this response was in relation to criticism being leveled at him for not taking the picture of a couch that was in the lounge. The defense had put to him that the accused was attacked by the deceased for the first time near the couch that is not depicted in the photograph album. That, in essence, concluded the evidence of the first witness, Malepe. Mrs. Elizabeth Marawa, hereinafter referred to as Marawa, the biological mother of the deceased, testified inter alia as follows.
Mrs. Elizabeth Marawa, Marawa,
the deceased was the youngest of her 4 children and her only daughter. The deceased was married with an 8-year-old daughter. However, she was separated from her husband. She had got to know about the relationship between the accused and her daughter 7 months prior to the death of the deceased. On the radio speaking about women and child abuse, and the deceased would comment about the accused. At a later stage, the deceased informed her that she was in a relationship with the accused. Marawa met the accused for the first time approximately a month before the death of the deceased, when he arrived at her home between 0200 to 03 hours 30 to see the deceased. She heard the deceased speaking to someone and decided to investigate. Upon her arrival at the door, she was introduced to the accused. She observed the accused holding a milk carton and that there was milk on the deceased and the floor. The deceased reported to her that the accused had spilt the milk on her. She reprimanded him for throwing the milk on the deceased. After reprimanding the accused, she departed and heard the parties continue to argue outside. During this argument, she overheard the deceased saying the following repeatedly. And I quote, "If you want to kill me, I don't care," close quotes. She testified that the deceased did not consume alcohol at home, but did not know if she consumed alcohol when she was away from home. She denied the proposition that the deceased had grabbed the milk carton from the accused, and in this process, the milk had spilt all over her. She stated to the accused that the deceased husband had never ever conducted himself in this manner with the deceased. It is noteworthy to mention that the accused had no response to this fact at the time. He did not deny pouring the milk on her. Marawa testified that the deceased was respectable, a good person who supported her family. That in essence concluded the evidence of the second witness, Marawa. Constable Joyce Mofokeng, hereinafter referred to as Mofokeng, a member of the South African Police Services and stationed at Morocco SAPS, testified inter alia as follows.
Constable Joyce Mofokeng, South Africa, station,
on 29 June 2014, upon reporting for duty with a colleague, Constable Tshabalala, she received instructions to look out for a white Fiat Palio with registration number VTP 297GP. Whilst traveling in central western Jabavu between 1500 to 1700 hours, she observed the aforementioned sought motor vehicle outside 1078 Makapa Street. It was parked adjacent to the street on the grass next to a tree. She then contacted Jabulani SAPS in order to report a fine and to confirm the registration number of the motor vehicle. She requested the presence of the forensic experts and photographers on the scene. Notwithstanding the fact that she had requested the presence of forensic experts and photographers, the aforementioned did not attend at the scene of recovery of the said motor vehicle. Upon further investigation, she observed that the motor vehicle was unlocked and that the ignition keys were missing. She subsequently received instructions from a commanding officer to remove the items that were found in the palio and to have the motor vehicle removed to the SAP 13 store. She removed bloodied items from the palio for further forensic analysis. She removed a blood-soaked pink woman's gown which was wrapped and whereupon the stains had begun turning dark. Grey tights, multicolored towel, clean gents striped shirt, and a pair of fawn pants which had been placed over the aforementioned items. These items were removed from near the windscreen. She observed that the pink gown had lots of clotted blood on it, as well as a grey pair of tights and multicolored towel. She found and removed a ShopRite plastic bag from under the front passenger seat which contained a wet white t-shirt. She found and removed a steak knife from the cubbyhole, and that the steak knife could be described as a regular steak knife which had a black handle. She found and removed clean gents' clothing from the rear seat of the motor vehicle. She discovered that these items of clothing were neatly packed. The motor vehicle, together with the items, were subsequently booked into the SAP 13 at Lenasia. Constable Joyce Mofokeng. That, in essence, concluded the evidence of the third witness. Ms. Palesa Matladi Seseli, hereinafter referred to as Seseli, the former neighbor and friend of the deceased and accused, testified inter alia as follows. Ms. Palesa Matladi Seseli, hereinafter referred to as Seseli, the former neighbor and friend of the deceased and accused, testified inter alia as follows. She had known both the accused and the deceased for several years prior to them engaging in a relationship with each other. She had known both the accused and the deceased for several years prior to them engaging in a relationship. She confirmed that the aforementioned were in a relationship for approximately 1 year prior to the death of the deceased. She confirmed that the aforementioned were in a relationship for approximately 1 year prior to the death of the deceased. She had known the deceased from a young age and had known the accused for approximately 8 to 10 years prior to the date of the incident. She had known the deceased from a young age and had known the accused for approximately 8 to 10 years prior to the date of the incident. Seseli testified that she had socialized with the aforementioned when they were a couple and that she had observed confrontations between them. She regarded these as normal and not very serious. Seseli testified that she had socialized with the aforementioned when they were a couple and that she had observed confrontations between them. She regarded She testified that on a certain day during November 2013, she was hanging out with the accused and the deceased at her residence. The accused and deceased thereafter departed. A short while later, she heard a knock on the door and saw the deceased with a bloodied nose. The deceased reported to her that she had been assaulted by the accused. The following morning, she attended at the SAPS Jabulani together with the deceased, as the deceased wanted to open a case of assault against the accused. The case was opened and the deceased was given Form J88 to complete regarding the injuries that she had sustained. Upon return from the SAPS, the deceased slept the night at her residence and departed to a parental home the following morning. Later that afternoon, the deceased returned to her residence in the company of the accused. The accused apologized for assaulting the deceased. This witness submitted that the accused had reconciled with the deceased in order to prevent her from continuing with the criminal case against him. I pause to mention that it was put to this witness during a cross-examination that the accused admitted slapping the deceased but denied that he was responsible for the bloodied nose. She recalled an incident during February 2014 when the deceased came upon the accused in the company of another female at her home. The accused indicated to her that his companion was a friend, whilst the companion indicated to the deceased that she was his girlfriend. The deceased became upset and proceeded to slap the accused as a result of these advices. The accused did not retaliate. During this altercation, the accused's female companion ran away. When the parties had calmed down, she overheard the deceased asking the accused as to, and I quote, "Why was he doing this to her?" Close quote. During February 2014 and at Ben's Tavern, she observed a second assault upon the deceased by the accused. The accused slapped the deceased as he suspected that she had been sexually abused by his friend while sleeping on the back seat of her car. He drew such conclusion from the fact that he had observed her belt unbuckled. Cecily was punched with a clenched fist on her right eye by the accused when she tried to intervene at the time when he was assaulting the deceased. It is noteworthy to mention that the accused was also involved in a scuffle with this friend. Cecily and the deceased then proceeded to SAPS Jabulani in order to open a criminal case against the accused. However, upon their arrival, they were unable to find the accused there, who had been previously taken from the scene by members of the SAPS. Notwithstanding this fact, they opened a case of assault against the accused and were handed J88 forms. Whilst proceeding home, the deceased received a call and thereafter reported to Cecily that the accused was at her parental home.
ga usu a bolela le se le gore mogala o o tswa mo wena o bona.
This witness advised the deceased that she was still upset and that she would not accompany her to her parental home. The deceased departed, and later that Sunday, she arrived at Cecili's home in the company of the accused, and she described them as being, and I quote what the witness had said, all lovey-dovey. She concluded that the case had been dropped against the accused. Cecily testified that she spoke to both the accused and the deceased about the relationship on a number of occasions. She stated that after the two aforementioned instances, she told the deceased that this could not continue and it was up to the deceased if she wanted to continue in the relationship with the accused. She stated that the couple would fight like any other couple and that in addition to the two aforementioned incidences of physical abuse by the accused, his emotional abuse of the deceased was constant. This fact was reported to her by the deceased. She knows the witness Nonhlanhla Mkhize, who was the deceased friend. She stated further that she was present when the accused, deceased, and the aforementioned socialized. She testified further that the deceased had allowed the accused to drive her motor vehicle, that means drive the deceased motor vehicle, on numerous occasions. She testified that both the accused and deceased were jealous of each other and were jealous of other persons coming in between the relationship. In addition, that both of them would have altercations with each other regarding their cell phones, more particularly the need for each of them to examine the contents of the other's cell phone. That, in essence, concluded the evidence of the fourth witness, Cecily. Dr. Moso Paul Marule, hereinafter referred to as Marule, medical doctor and forensic medical specialist, attached to the medical legal section of Forensic Pathology Services Johannesburg, testified inter alia as follows.
Dr. Moso Paul Marule,
that he has been conducting post-mortem examinations for a period of approximately 20 years. On 30th June 2014, he conducted a post-mortem examination upon the deceased and found the chief post-mortem findings to be, and I quote, a penetrating wound on the pubis on the midline, severed main blood vessels on the right thigh, proximally deep to the wound, close quotes. The cause of death was determined as penetrating wound of the right thigh, severe blood loss, and hypovolemic shock. He stated that hypovolemic shock results from severe wounds and loss of blood and fluid. He observed a 3 centimeter by 1 centimeter penetrating incised wound on the midline. This wound was horizontal across the midline, which was deep and extended into the root of the right thigh medially. He observed the main vessels underneath the wound, being the right femoral artery and vein, were severed deep to the wound. The presentation and anatomical changes of the various organs were commensurate with severe loss of fluid and or blood. Save for the penetrating incised wound that he found on the deceased, he did not observe any other signs of injury upon the body of the deceased. Morule was clear that the deceased did not have any other defensive wounds. Morule testified that his findings were consistent with the use of a steak knife as the instrument that was used to inflict the fatal wound. He was unable to equate a numerical term to the amount of force used to cause such wound upon the deceased. However, he was certain that the force applied was significant to get the result of the wound. He explained further that arteries carry blood that is under great force as opposed to veins. Due to such difference in roles within the body, arteries are thicker, tougher, and more elastic than veins. Therefore, by their very physical structure, one would need to apply quite a substantial amount of force upon the artery in order to penetrate it, as opposed to a vein. The witness, having been shown the photo album and more specifically the environment, was clear that there was evidence of blood loss on the bedding whereupon the deceased lay. In addition, the presentation of the bloodstains on the fridge and the door frame of the toilet and the intensity thereof was clearly indicative of the fact that the scene was wiped up. Morule testified that in order to result in death, a human being would need to lose approximately 2.5 liters of blood, which would equate to 1/3 the total blood volume of 5 to 6 liters which is in the human body. Save for the blood that oozed out of the deceased on the bed, the rest of the environment did not show such a significant amount of blood which he would have expected to have observed. The witness, having referred to the photographs of the lounge and its contents, was clear that the scene had been wiped up. Morule testified that the deceased would have been saved with this type of injury had the deceased been taken immediately to casualty, having due regard to the fact that the Jabulani hospital was approximately 900 meters away from the crime scene. Marule stated that the wound was in an anatomically dangerous area, but fatal due to the fact that there was no timeous medical intervention. That, in essence, concluded the evidence of the fifth witness, Dr. Marule. Mr. Matopa, would this be a convenient point to take the short adjournment? Thank you. The court will take the short adjournment.
Which is wrong, that please.
Please, Madam. Lord, the accused is requested if we can continue without the interpreter.
Without the interpreter.
Interpreter, just as a matter of time sake, because he doesn't understand.
Thank you, Advocate Matopo. In fact, I was looking for the court interpreter, but I see she's seated here. All right. Mr. Sebolai, the court is going to continue with delivering its judgment. Your counsel, Advocate Matopo, has informed this court that you have no objection to the court then proceeding with its judgment in English. Would you confirm that? Would you be able to understand and follow the proceedings? Thank you. All right, you may be seated. After the short adjournment, the court continues with its judgment. Captain Mashadi Phineas Masetla, captain in the SAPS and senior forensic analyst attached to the biology section of the Forensic Science Laboratory with 17 years of experience in the biological sciences, testified inter alia as follows: that he completed a forensic analysis upon the exhibits that were submitted to him for examination. The DNA analysis completed by this witness was handed in as Exhibit K. That from the samples presented to him, he concluded as follows: the swabs taken by Melepi contained blood of the deceased. The pair of pants recovered from the dustbin belonged to the accused, and that the bloodstains thereon to the deceased. The items found in the motor vehicle contained the blood of the deceased. In addition, one pair of jeans contained a speck of blood from the accused. He was unable to obtain DNA from the knife. As per his examination, he was able to find blood of the deceased on numerous items of clothing, including the towel, whilst that of the accused on a pair of jeans and a stain on the high friction area of his pants. He was unable to speculate as to when the blood of the accused could have come into contact with the above-mentioned clothing, and as such was unable to confirm if the accused was bleeding on the day of the incident. That, in essence, concluded the evidence of the sixth witness. Ms. Aurelia Nonhlanhla Mkhize, hereinafter referred to as Mkhize, friend of the accused and the person who made the first report to the South African Police Services, testified inter alia as follows. She was the childhood friend of the deceased. On 28 July 2014, Mkhize and the deceased attended a funeral. The accused borrowed the deceased motor vehicle as he needed to attend work. Later that evening, Mkhize and the deceased proceeded to Herman's Tavern in Soweto, where they went to socialize. The accused arrived later and beckoned to his watch, indicating that he wanted to leave. The three of them then departed from the tavern and proceeded to Mkhize's motor vehicle in order for the deceased to collect her clothes. The deceased then left with the accused. This was the last time she saw the deceased alive. On the morning of 29 July before 0700 hours, while still asleep, she received a telephone call from the deceased's cell phone. When she answered the call, she realized that it was the accused on the other end of the phone. The accused then said to her, and I quote, "Nonhlanhla, I killed Dolly," close quotes. She responded to him by stating that he was lying to her, whereupon he said, and I quote, "I am serious, I killed her, she is dead," close quote. The witness confirmed with him as to whether he was serious, and he acknowledged that he was serious about what he had told her. He said, and I quote, "Dolly is indeed dead," close quote. Mkhize then instructed him to perform CPR, that's cardiopulmonary resuscitation, upon the deceased. The accused responded by stating that he had in fact performed mouth-to-mouth resuscitation on the deceased and that she was cold. Mkhize was not convinced with what the accused had reported to her regarding the deceased. She thought that he was joking. She then suggested to him that they must meet at the BP service station close to the Baragwanath hospital. She further requested the accused to bring the deceased along. The accused responded by stating that he would, and I quote his words, "get back to her," close quote. She then proceeded to the BP service station in order to await the arrival of the accused. However, he never arrived. Mkhize then called the accused in order to find out his whereabouts. During his telephone call, the accused stated, and I quote, that Dolly was sleeping, whereupon she requested him to give the deceased the phone. The accused then said the following, that she had blacked out and that she was drunk. Mkhize did not believe the accused story and thereupon asked a friend, Khateko, to call the accused, whilst pretending that she was supposed to have gone to church with the deceased that morning. As a result of this telecon and receiving the report from the aforementioned, Mkhize called the accused again. She then arranged to meet with the accused at one Tyson's Tavern. However, she said to the accused that she could not make any final arrangements without having spoken to the deceased. The accused during this conversation once again reiterated that he killed the deceased and further that he was going to flee to Botswana. Mkhize thereupon proceeded to the Jabulani SAPS and made a report of the matter and requested members of the SAPS to accompany her to the flat of the accused. Access to the flat was subsequently obtained by this witness and members of the South African Police Services at approximately 10:00 hours that morning. It is noteworthy to mention that the accused, during cross-examination of this witness, admitted to having lied about the true condition of the deceased and had said to her that he was with the deceased having breakfast at the Nansfield hostel. The witness vehemently denied the allegation that she was involved in a physical relationship with the accused. She further denied that she and the deceased had ever engaged in sexual intercourse with the accused as a so-called threesome as alleged by the accused. She added that this simply could not have happened as she did not have the same taste in men as the deceased, and further that she did not fit the profile of a woman that particularly attracted the interest of the accused. That in essence concluded the evidence of the seventh witness, Mkhize. Warrant Officer Pila Esram Mabitsi, warrant officer in the South African Police Services with 29 years of service and stationed at the Jabulani Visible Policing Unit, testified inter alia as follows. The witness testified about 3 occasions when he attended complaints at the residence of the accused. The first being during February 2014, when the deceased attended at the police station and complained to him that the accused was fighting with her and had threatened her with physical violence. He accompanied her to the accused's flat, which was approximately 900 meters away, whereupon he found the accused. He observed that the accused had been drinking. The deceased informed Mabitsi that the accused was her boyfriend and that they had been fighting. He spoke to both of them and duly reprimanded them. The accused apologized and admitted that he had made a mistake. The second occasion was again during the month of February 2014, when the deceased attended at the police station again. She complained that the accused was fighting with her. Mabitsi advised her to obtain a domestic violence protection order against the accused, as she did not want to lay a charge against him. The deceased informed this witness that the accused had threatened to beat her up and kill her. The third occasion was during the month of March 2014. The deceased arrived at the police station and reported that the accused had informed her that he did not want to be in a relationship anymore with her, and that she required the assistance and presence of the SAPS in evacuating her from the accused's residence. Mabitsi then accompanied her to the accused's flat, wherein he found the accused. The accused then said to him, in the presence of the deceased, that he did not enjoy sexual intercourse with her anymore and that her vagina has stretched. As such, he did not want to be in a relationship with her. The deceased then contacted her brother to assist with the removal of her things from the accused's flat. The deceased subsequently packed up her belongings and left in her motor vehicle. This witness then departed the scene. Mabitsi testified that the deceased reported to him that the quarrels that the accused and the deceased had could be described as lovers' fights. The parties would argue and then the accused would push her around. This essentially would be their fights. He testified that from his observation, the parties loved each other, but was of the opinion that the problem of the accused was liquor, as he liked drinking. Mabitsi testified that he had advised the deceased to obtain a protection order against the accused, as the accused kept fighting with her, and on the contrary did not advise the accused to obtain such order against the deceased, as he was not the victim in the circumstances but the aggressor. That in essence concluded the evidence of the eighth witness, Mabitsi. Detective Sergeant Guth Ilenda Moses Hlabati, Detective Sergeant in the South African Police and stationed at the Protea Glen SAPS Vehicle Identification Section, testified inter alia as follows. On 7 July 2014, at approximately 22 hours 30, he received certain information regarding the accused. As a result of such information, he decided to hold observation at Dube village in the company of his colleague, Sergeant Mdluli. At approximately 07 hours 30, Hlabati received a telephone call from his informer, who requested him to rush to Dube as the accused was going to be visiting a house next door to his residence. The officers duly held observation of the house which the accused was alleged to be visiting that morning. At approximately 0900 hours, a gold Toyota Cressida was observed arriving at the house upon which they were holding observation. He observed two persons alighting from the said vehicle and entering the house. The passenger was wearing a jacket with a hood that was pulled over his head. The informer confirmed to him that the passenger was in fact the accused who was being sought by the police. A period of approximately 10 minutes elapsed, and Hlabati observed the accused and the driver emerge from the house and enter the Cressida. The motor vehicle then drove off. Hlabati and his companion then followed this vehicle. A short distance later, he stopped the vehicle and instructed the occupants to alight from the vehicle. He then approached the accused and asked him if he was Donald Sebolai. The accused confirmed that he in fact was Donald Sebolai. He thereafter placed the accused under arrest. He was clear that at no stage did the accused ever indicate to him that he was on his way to the police station. Further, from his observation, the accused was not heading in the general direction of the police station, as there was only one route one could take, taking cognizance and having due regard to the direction in which the motor vehicle was traveling in. He testified that the vehicle was traveling in the opposite direction of the Dube or Jabulani SAPS. That in essence concluded the evidence of the ninth witness, Hlabati. Detective Warrant Officer Mbazima December Tshabalala, Detective Warrant Officer in the South African Police with 24 years service and stationed at the Jabulani SAPS, testified inter alia as follows. On 29 June 2014, he attended the scene of crime and was the police officer in charge of such scene. The flat was found locked and his initial decision was to break in. However, the caretaker subsequently arrived and opened the flat for members of the SAPS. Tshabalala duly accompanied the photographer, Malepi, and pointed out certain aspects to him for him to photograph. The scene was found by him as depicted on the photo album, which is Exhibit C in these proceedings. He also confirmed finding the various items that were found on the scene, namely at the accused's flat and surround. He corroborated the evidence of Malepi regarding the scene and items recovered thereat. He confirmed that the vehicle of the deceased had been reported missing, and as such, he circulated the motor vehicle. He later received information that afternoon that the abandoned vehicle had been found by members of the Morocco SAPS near White City. He then proceeded to the scene of recovery and confirmed that the vehicle recovered belonged to the deceased. The vehicle was found approximately 2 to 2.5 kilometers away from the Jabulani flats, being the scene of crime. He testified that there was no blood found on the couches, hence he did not deem it important to have same photographed. That in essence concluded the evidence of the 10th witness, Tshabalala. Shimane Ndlovu, hereinafter referred to as Ndlovu, resident of flat 206, Block D, Jabulani Flats detective, Jabulani Flats, testified inter alia as follows. He was standing on the balcony of his flat on the morning of 29 June 2014 and smoking. At approximately 1000 hours, he observed the accused walking to and from the deceased motor vehicle. He greeted the accused on the first occasion when he was returning from the vehicle, and he was ignored. Approximately 2 minutes later, he saw the accused walk towards the car from the direction of his flat, and on the second occasion, he was carrying clothing in his hands, which he put into the deceased's palio. On this occasion, the accused greeted him when returning to the flat. The accused, after locking his flat, then got into the motor vehicle and left the premises. That was the last time that he saw the accused. He testified that the accused looked like someone in thought at the time when he saw him walking to and from the motor vehicle. That, in essence, concludes the evidence of the 11th witness, Ndlovu. Detective Constable Isaac Opa Kubeka, hereinafter referred to as Kubeka, Detective Constable in the South African Police with 10 years service and the investigating officer stationed at the Jabulani SAPS, testified inter alia as follows: that he attempted to trace the accused upon receiving the case docket to no avail. He further testified that as a result of such failed attempts, he engaged the services of informers, offered a reward of 50,000 rand for information leading to the arrest of the accused, advertised a reward to the print and visual media, used community and commercial radio, and duly applied for a J50 warrant for the arrest of the accused, and same was circulated within the SAPS. He testified that this matter was circulated throughout the country. On 8 July 2014, he received information that the accused had been arrested. He subsequently found the accused in custody at the Jabulani SAPS. The witness testified that when he saw the accused for the first time that day at the back of the police station, he appeared to be light-hearted and he was laughing and joking with members of the public, of the media and police officers who were standing by. Kubeka confirmed that he interviewed the accused and took down his warning statement later that evening at approximately 2100 hours. At the commencement of the interview, he informed the accused that he was the investigating officer in this case and that he was going to proceed to charge him. The first words that the accused uttered thereupon was, and I quote, "I hate women," close quote, while slamming his hand on the table and appearing to be very angry. When he queried the statement with the accused, he responded by saying, and I quote, "Look where I am today," close quote. Further, that the accused was angry at being arrested. During the interview, Kubeka requested the accused to show him any injuries that he had on his body, whereupon the accused showed him, and he noticed, and I quote from the warning statement of the accused as recorded thereon, marks on little finger, comma, ring finger and middle finger, close quote. The marks were slightly visible, not clear, comma, they had faded, close quote. The accused advised him that he was injured by the deceased when she wanted to stab him. This witness testified that the marks on the accused's hand did not appear to have been recently inflicted. The accused was cooperative during the interview and was desirous to tell his version. At no stage was there any hesitation on the part of the accused during the interview. Kubeka was of the view that the accused was not remorseful and had appeared normal during the interview. He testified that the flat of the accused was situated approximately 900 meters from the Jabulani SAPS and that the hospital was approximately a further 100 meters away from the police station. The fire station is also next door to the police station and hospital. The witness stated that he could not believe the version of the accused, that he had been injured by the deceased as he was at large for a period of 9 days and that he could have been injured during this period. Kubeka testified that the accused appeared to be much Kubeka testified that the accused appeared to be much larger in size at the time of his arrest as compared to what the witness observed the accused to be at the time when this witness testified during the trial. That, in essence, concluded the evidence of the 12th witness, Kubeka. The state then handed in by consent the bail proceedings that were held in the magistrate's court as Exhibit S. The state further informed this court that state witness number 4 on the list of witnesses, Kelebokhile Leti Selekani, the sister of the accused, was not going to be called by the state and accordingly made available to the defense. The case for the state was accordingly closed. Mr. Vusumuzi Donald Sebolai, hereinafter referred to as accused, former radio presenter at Jozi FM, duly testified in his own defense and inter alia testified as follows. The accused testified that he was employed for a period of approximately 10 years at Jozi FM. In addition, he did some work as a DJ in clubs, pubs and parties. He testified that he met the deceased during August 2013 at a friend's place and commenced a love relationship with her thereafter. He loved the deceased very much and fell in love with her the first time he saw her. He was aware that she was also known as Dolly. However, he was of the view that he needed to find a special name for her and referred to her as Lala. He confirmed that there were fights and arguments between them in the normal course of a love relationship, and these were as a result of jealousy. He testified that their relationship was fine during the week. However, they would always fight on the weekends, which he attributed to his work as a DJ. According to him, the deceased did not like his DJ work as he did not get sufficient time to spend with the deceased. In addition, the deceased had a problem with his weekend work as he was surrounded by women who wanted to hug and take photographs with him. He testified that both of them loved each other, and due to jealousy, they would check each other's phones as they wanted to know what the other person was doing. He testified that the deceased had a problem with the fact that he would communicate with his eldest child on his mother's phone. The deceased would instruct the accused to put the phone on speaker in order for her to hear the conversation. The deceased would become angry when she would hear the voice of the mother and when the mother communicated with the accused. The accused confirmed having been present at Marawa's house during the evening as testified by Marawa. However, he testified that he had attended at 2300 hours after he had been summoned there by the deceased. Upon his arrival, the deceased accused him of having visited his prostitutes and thereafter held him by his jacket. The accused then pushed her while saying to her that she should leave him. During this process, the milk was spilt on the deceased. He testified that on one occasion he was slapped by the deceased whilst he was at Cecili's home as a result of his companion saying to the deceased that she was his girlfriend. The accused further testified that later the same day he met with the deceased and they spoke about the earlier events. They then solved the matter, and according to him, they became even closer. They bonded even more with each other instead of parting ways. The accused admitted that he had assaulted the deceased on the two occasions Cecily testified about. However, he denied that he was responsible for the deceased's bloodied nose during the first assault. The accused testified that he slapped the deceased on another occasion whilst they were driving in the deceased's motor vehicle as she was interfering with his cell phone by sending BBM messages to his child's mother. During his cross-examination, he explained that he slapped her in order to reprimand her and that he did not see anything wrong with his behavior if couples in a relationship would reprimand each other in this way. He testified that on the occasions when they had arguments and fights, they would always reconcile their differences and forgive each other. The accused testified that he had a sexual relationship with eNCA and the deceased at the same time on 3 occasions. He called it, and I quote the accused, a game of adults, close quotes. The accused further testified that it was the deceased who put a stop to this arrangement as she was jealous that the accused had desired eNCA more than her. The accused confirmed the occasions that Mabitsi testified about regarding the complaint that he had received from the deceased. The accused confirmed that he had pushed the deceased out of his flat, which led her to raising a complaint with the SAPS. He testified that he had on one occasion proceeded to the SAPS Jabulani in order to have the deceased evicted. Whilst in the motor vehicle, they discussed the matter and resolved their differences. The accused testified that the deceased allowed him the use of a motor vehicle on a regular basis. The accused testified that on the evening of 28 June 2014, he attended Herman's place in the company of his younger sister and a work colleague. The purpose of his visit there was to fetch the deceased. Upon departing Herman's place, they proceeded to Jerry's place in order to purchase alcohol. He testified that the mood was good between the deceased and himself. Early on the morning of 29th of June 2014, they proceeded to his flat. During this journey, an argument ensued between them as a result of the deceased taking the accused's cell phone. The accused did not like this conduct of the deceased. The argument continued whilst they walked into the flat, with the deceased insulting him. Whilst inside the flat, the argument then progressed onto the subject of the accused son visiting for the holidays. The accused indicated to the deceased that she should not visit him in the 3 weeks as he wanted to spend time with his child. The deceased then said to him that he is crazy and that this would never happen. The argument continued and the deceased became angry. At a certain stage during the argument, the deceased armed herself with a bread knife and tried to stab him twice. He disarmed her by grabbing hold of the deceased's hand and squeezing it tight with both his hands. The deceased exclaimed that the accused was hurting her, lost power in her hand, and the knife fell to the ground. The accused then placed the knife on the table as depicted on photo 42 of Exhibit C. The accused then lit a cigarette and smoked inside the flat, much to the annoyance of the deceased. The accused then informed the deceased that he was supposed to fetch the child and that they should retire to bed. He then reiterated his earlier request to the deceased, where he informed her that she should not visit him during this period, that the child was with him. The deceased retorted that he was lying to her and that he in fact wanted to spend time with the mother of his child, and that the accused was a loose man. The accused believed that he provoked the deceased. The deceased then armed herself with a steak knife whilst she was seated on the couch, which is depicted as point X1 on the photo album. The deceased held the knife in her right hand in a stabbing motion. The accused moved back and he fell down. As he stood up, he pushed the deceased. The deceased returned and continued stabbing whilst he blocked her blows with his right hand. At this stage, he was stabbed. The accused then said to her that she is stabbing him. The deceased attempted to stab him again and missed. On the next attempt, the accused grabbed hold of the knife with a clenched fist. The deceased twisted the blade whilst the accused was holding the blade. The knife was cutting him, and as it was painful, he let go of the knife. At the time when he released the knife, the deceased attempted to stab him again, but missed. The accused then grabbed the deceased's hand that held the knife and they struggled over the knife. The accused instructed the deceased to leave the knife. The accused testified that he tried to press her hand hard, but could not do so as he was now injured on his hand and was bleeding. At this stage, they were standing in front of the bedroom door. The accused then attempted to pull the knife away from her, whilst the deceased was attempting to pull the knife towards her. Both of them were involved in a pulling motion in opposite directions. The accused then heard a sound emanate from the deceased that sounded like the deceased had clenched her teeth and a sharp inhalation of her breath. The accused then saw blood running down the right side of the right thigh of the deceased, on the leg of the pajama that she was wearing. He felt scared when he observed this. The accused testified that he observed a lot of blood flowing from her inner thigh down her leg. At this stage, he was bleeding from his palm. The accused then decided to run to the bathroom to cover his hand so that he could help the deceased. The accused then rinsed his hand and wrapped his palm with a clean cloth that he found on the floor. Upon his return to the deceased from the bathroom, he observed lots of blood on the floor and some on the carpet. The deceased was not saying anything to him at this stage. As a result of seeing the aforementioned blood, the accused went back to the bathroom to fetch the towel and placed it on the thigh of the deceased. The accused told the deceased to hold the towel. The deceased was quiet at this stage. The accused then held the deceased by her waist and took her to the bed. She sat down whilst he lifted her legs in order for her to lie down. The accused thereafter took the deceased's pink gown and placed it on the blood that was on the floor. The accused testified that thereafter he rinsed his hand and wrung the cloth that was covering his palm as it was wet with blood. The accused thereafter returned to where he had left the pink gown and proceeded to wipe up the blood with the gown. The accused stated that he was in a state of shock and did not know why he was wiping up the blood. He thereafter took the mop and continued wiping blood from the floor. At this stage, he called the name of the deceased while still wiping the blood, and she responded. The accused called out to the deceased, "Lala," to which she responded, "Yay," and did not say anything else. The accused thereafter told the deceased that he was nearly finished wiping the blood, and thereafter he would take her to hospital. The accused thereafter entered the bedroom and observed that the towel that he had placed on the thigh of the deceased had blood on it, as well as her pyjama pants. The accused then said to the deceased that he needed to change her clothing as they were bloodied, and that he would put on clean clothes for her so that he could take her to hospital. The accused testified that he thought it essential to change the deceased's clothing as he wanted to show the staff at the hospital as to how much the deceased had bled. The accused testified further that the deceased assisted him by moving herself whilst he removed her pyjama bottom and replaced it with a pair of tights. During this process, he requested the deceased to move, and she duly complied. However, she was not speaking. The accused thereafter told the deceased that he will take the bloodied items to the car and that he will return for her. He thereafter took the bloodied pink morning gown, towel, steak knife, and the pyjama trouser and placed them in the deceased's motor vehicle. Upon his return to the flat, he called out her name and said, "Lala, Lala, wake up so that I can take you to hospital." The accused then proceeded to the bedroom and found the deceased not responding. He called her name again and shook her. The deceased was not responding. He then attempted CPR, but to no avail. He was shocked and did not know what to do. The accused did not believe that the deceased had died and proceeded to sit on the couch, hoping that she would wake up. A while later, the accused returned to the deceased, called her name and shook her, but there was no response. The accused then proceeded to the bathroom and observed blood on the carpets. He then collected same from the bathroom and placed it in the washing machine. He did not switch on the washing machine. The accused then went into the spare bedroom and saw his previously washed clothes on the ironing board. He then removed the clothes and placed them in the deceased's motor vehicle. He was unable to provide any reason for doing this. The accused then returned to his flat, went into the bedroom, and called out the name of the deceased. She did not respond to his calls. The accused then testified that he heard the deceased's phone ringing. He answered the call and realized that it was Mkhize on the other side. She inquired as to the whereabouts of the deceased. The accused told her that both himself and the deceased were at Mansfield having something to eat. This witness had previously known of this venue. Mkhize then said to the accused that he must inform her when they had finished eating. The accused stated that he told Mkhize the aforementioned as he thought that the deceased would somehow wake up. The accused then returned to sit on the couch, and whilst there, thinking about whether the deceased mother would believe him when he told her as to what had happened. A second conversation took place between him and Mkhize, wherein he advised her that both him and the deceased were purchasing ciders at Tyson Park in Pimville, Soweto. The accused stated that he was essentially buying time as he thought that the deceased would wake up. Thereafter, he took the deceased's phone and called Mkhize. During this conversation, he reported to her that Dolly has passed on. Mkhize responded by saying that he was joking and that he should stop making jokes. The accused then repeated to her in Zulu, and I quote the English, "I am telling you the truth, that Dolly has passed on," close quote. The accused then returned to the bedroom where he called out the name of the deceased again, thinking that she may wake up. The accused thereafter took the deceased's cell phone and telephoned the deceased's estranged husband and informed him that the deceased had passed on. He further advised the aforementioned that she had passed on in Jabulani at the flats. The accused then changed his bloodied Daniel Hector pants, which he described as fawn in color, and departed from the flat. The accused testified that he called his sister for help but could not recall what the conversation was about. After he had spoken to her, he drove off in the deceased's motor vehicle. The accused recalled that he left the vehicle abandoned at Central Western Jabavu, Soweto, not before passing out behind the steering wheel. Upon regaining consciousness, he alighted from the motor vehicle and wandered around Soweto for the following 9 days without food or water. During this time, the accused recalled that he was at a park in Mfulo and it had drizzled that night. After a few days, his mind began clearing, and then he realized that he required the assistance of someone who could hand himself over to the SAPS. The person who fitted this profile was one Saki, who was married to the accused's cousin. On the morning of 8 July 2014, the accused walked to Saki, who was surprised to see him. When queried about where the accused had been sleeping and what he had been eating, he responded that those details were unimportant and that he said to Saki, and I quote, "Please take me to the SAPS," close quote. And when asked which one, he said, and I quote, "Jabulani," close quote. Both of them then prepared themselves, with the accused taking a bath. They then departed from Saki's home. However, Saki reported to him that he needed to have fuel in his Cressida motor car and that they needed to first go to a service station. As they left Saki's house, they were stopped shortly thereafter and the accused was arrested. The accused confirmed that Kubeka had taken a warning statement from him, but denied that he had said that he hates women. The accused, during cross-examination, admitted that he said to the deceased on more than one occasion that he did not want her and threw her out more than once, due to the fact that he was angry with her. The accused confirmed that during many of the crucial questions that were put to him during cross-examination in the bail application, he chose to remain silent as a result of not understanding court procedure, despite being legally represented during such application. That, in essence, concluded the evidence of the accused. Professor Sats Cooper, hereinafter referred to as Cooper, clinical psychologist in private practice with 30 years of experience, testified inter alia as follows: that he was approached by the instructing attorney to evaluate the psychological state of mind of the accused and thereon to prepare a report regarding his findings. Cooper evaluated the accused and captured the accused's responses in his own words. He prompted him where necessary and left the narrative to him. He stated that his modus operandi was to be highly skeptical of what he hears from the accused. He observed that the accused exhibited signs of depression and receding signs of post-traumatic stress syndrome. He did not read the contents of the police docket and therefore could not confront the accused with the facts of the state's case. The only collateral source used by Cooper was the erstwhile employer of the accused and his sister. This anomaly caused Cooper to concede that the fact that he was unable to obtain other sources of collateral information created a caveat in his testimony, in that if this court were to find the evidence of the state witnesses, if this court were to find the evidence of the state witnesses is credible, it would change his mind regarding the findings of credibility of the accused's version. Cooper testified that the accused exhibited fairly disorganized patterns of behavior post the event, which he attributed to the shock of what had happened. Consequently, the accused went into a state of disassociation, which caused the accused to go into a lock mode. During one of the sessions that he had with the accused, he hypnotized him, and based upon what the accused related to him, concluded that the version of the accused is the truth. Cooper testified that when he prompted the accused about why he did certain things, there was no rhyme or reason why certain things happened. Further, that there was jaggedness in the memory of the accused, especially after the injury of the deceased. Cooper further testified that the accused was in a state of bewildered wandering during the period of 9 days after the incident. That the accused had feelings of intense remorse due to the fact that he wished that this incident had never happened. Cooper conceded that his report could be said to be flawed as it only contained the version of the accused. He further conceded that the accused was in a panic state and hence it became necessary for him to cover his tracks. Cooper stated that he could not exclude the possibility that the accused unwittingly stabbed the deceased. That, in essence, concluded the evidence of the only defense witness, Cooper. The defense then advised this court that it had no further witnesses that it intended calling and that it will not be handing the recording of the interview and hypnotherapy of the accused. Counsel for the defense, Mr. Matopo, accordingly closed the case for the defense. Ms. Leroux then brought an application for the reopening of the state case, and more specifically to recall Dr. Marule, the forensic pathologist. After hearing argument from both parties and having carefully considered the application at hand, this court granted leave for Dr. Marule to be called. Dr. Maso Paul Marule, medical doctor and forensic medical specialist attached to the medical legal section of Forensic Pathology Services, Johannesburg, testified further inter alia as follows. Marule confirmed that the steak knife that was shown to him by the state was commensurate with the weapon that was used to inflict the fatal wound upon the deceased. He testified that the injury that was caused on the deceased was significant, and usually significant injuries are sustained when sufficient force and kinetic energy is used to cause injury. That having due regard to the manner in which the accused described that he grabbed the hands of the deceased during the struggle for the knife, one would have expected to have noted the effects of the struggle upon the deceased. In this instance, there were none. Further, that in the case of a struggle for a weapon, as described in this case of clutching, then one would have expected to observe the normal pattern of injury to the hands, wrists, back of the hands, nails and distal parts, and there would be abrasions and scratches. He did not find any of these features on the deceased during the post-mortem examination. That the normal human reaction when there is risk of self-injury is for the individual to bring an end to the process of injury. One would have a reflex action that would make one stop. He concluded that the injury sustained by the deceased was uncharacteristic of accidental self-inflicted injury. That the general pattern of lethal injuries are homicidal, followed by suicidal, and accidental would be the last unless an individual wanted to terminate their own lives. From the evidence before the witness at this stage, there was no evidence that the deceased wanted to commit suicide. He examined the deceased's body specifically for signs of violation and found absolutely no signs of defensive wounds. He did not find any injuries or bruising on the wrists and hands of the deceased. Marule reiterated that save for the one fatal wound on the body of the deceased, he observed no other injuries upon the deceased. He stated further that a significant amount of force was applied in order to cause the wound of this nature. Marule testified that the knife was at an oblique angle when it penetrated the deceased. Further, that it would have been difficult for the deceased to have caused the wound, having due regard to the orientation of the parties during the struggle as testified to by the accused. That due to the total severing of the femoral artery, it was improbable for the deceased to inflict the injury upon herself. That, in essence, concluded the evidence of Marule. The state then closed its case. Upon evaluation of the state's case, it is clear that the evidence of the state can be divided into three sections. The first being the history of the relationship between the accused and the deceased. In this regard, the state has led the evidence of the following witnesses. Mrs. Marawa, who testified about the milk carton incident and wherein she heard the deceased saying to the accused, "If you want to kill me, I don't care." Ms. Siseli, who testified about the incident during November 2013 when the deceased returned to her residence with a bloodied nose and reported to her that the accused had assaulted her. The incident when the deceased was informed by the companion of the accused that she was his girlfriend, which resulted in an argument between the deceased and accused, when she slapped him and was overheard asking the accused, why was he doing this to her? The incident during February 2014 at Ben's Tavern, when the accused assaulted the deceased when he thought that she was being sexually taken advantage of by his friend. Ms. Mkhize, who testified about the relationship between the accused and deceased. Warrant Officer Mabitsi, who testified about the incidences when the deceased attended the police station and when he had to proceed to the flat of the accused in order to reprimand him, as well as other instances. The second being the incident on 29 June 2014 when the deceased was fatally wounded. It must be noted that the state does not have any evidence regarding the actual incident between the accused and deceased, save for the evidence of the accused. The third section being the period between 29 June 2014 to 08 July 2014, subsequent to the death of the deceased. In this regard, the state called the following witnesses whose evidence can be regarded as direct and or circumstantial. Ms. Mkhize, who received the telephone call from the accused at approximately 0700 hours, wherein he stated to her, and I quote, "Nonhlanhla, I killed Dolly," close quotes. He further stated, "I am serious. I killed her. She is dead," close quote. Mr. Ndlovu, who testified about seeing the accused placing items of clothing in the deceased's motor vehicle. Constable Malepi, the officer who attended the scene and took the photographs. Detective Warrant Officer Tshabalala, who attended the scene of crime and the officer in charge of the scene. Constable Mofokeng, who recovered the motor vehicle and items of clothing later that day. Dr. Marule, who conducted the post-mortem examination upon the deceased. Captain Masetla, who conducted the DNA analysis of exhibits that were forwarded to him. Constable Tabati, who held observation and arrested the accused. And lastly, Detective Constable Kubeka, the investigating officer who interviewed the accused and took down his warning statement. It is common cause that the accused and deceased had a tumultuous relationship. It is common cause that the accused assaulted the deceased during the relationship, as admitted by him and testified to by the witnesses. It is common cause that the accused wiped up the scene of crime and removed items of clothing and the knife from the scene. It is common cause that the accused departed with the deceased motor vehicle after the fatal stabbing of the deceased. It is common cause that the vehicle was later found and that the items were recovered from the said vehicle. It is common cause that photographs of the scene were taken on the day in question. It is common cause that a post-mortem examination was conducted on the body of the deceased. It is common cause that the accused was arrested by Constable Tabati whilst traveling in a gold Toyota Cressida. It is common cause that the investigating officer interviewed the accused and took down his warning statement. It is common cause that there is no direct eyewitness evidence regarding the stabbing of the deceased. The prosecution relies upon circumstantial evidence to prove the case against the accused. I pause to mention that the only evidence before this court regarding the stabbing of the deceased is that of the accused. The cardinal rules of logic as stated in R versus Blom, 1939, AD at 202 to page 203, and also in S versus Mtsweni, 1985, volume 1, SA 590, an appellate division decision case at page 593, stated as follows are the accepted method of reasoning by inference. The inference sought to be drawn must be consistent with all the proved facts, which should include every reasonable inference save the one sought to be drawn. In other words, the inference must be distinguished from speculation and must be based on properly objective facts. Close quote. The quote from the judgment of Malan J.A. in R versus Mlambo, 1957, volume 4, 727, an appellate division decision case at 738A and B is apposite, and I quote, "In my opinion, there is no obligation upon the Crown to close every avenue of escape which may be said to be open to an accused. It is sufficient for the Crown to produce evidence by means of which such a high degree of probability is raised that the ordinary, reasonable man, after mature consideration, comes to the conclusion that there exists no reasonable doubt that an accused has committed the crime charged. He must, in other words, be morally certain of the guilt of the accused. An accused's claim to the benefit of doubt, when it may be said to exist, must not be derived from speculation, but must rest upon a reasonable inference which are not in conflict with or outweighed by the proved facts of the case. Moreover, if an accused deliberately takes the risk of giving false evidence in the hope of being convicted of a less crime, or even, perchance, escaping conviction altogether, and his evidence is declared to be false and irreconcilable with the proved facts, a court will, in suitable cases, be fully justified in rejecting an argument that, notwithstanding that the accused did not avail himself of the opportunity to mitigate the gravity of the offence, he should nevertheless receive the same benefits as if he had done so." Close quote. This court, at the end of the day, is now called upon to appraise the circumstantial evidence of the state and balance that with the version of the accused in order to determine the guilt or the innocence of the accused. The accused's plea at the outset of this trial is that he acted in self-defense. By definition, a person acts in self or private defense, and his act is therefore lawful if he uses force to repel an unlawful attack which has commenced or is imminently threatening upon his or somebody else's life, bodily integrity, property or other interests which deserves to be protected, provided the defensive act is necessary to protect the interest threatened, is directed against the attacker, and is reasonable, proportionate to the act. This definition was accepted by the court in State v. Engelbrecht, 2005, Volume 2, SACR 41, Witwatersrand Division Decision Case, as it was then known, at page 228. I have duly taken note of all the background white noise introduced by the accused during the course of this trial, and am of the view that it does not merit detailed discourse in order to make a final determination in this matter. Hence, for the purposes of this judgment, this court will not deal with all the peripheral and side issues that was introduced during the course of this trial. I wish to state that the witnesses who testified before this court gave their evidence in a straightforward and honest manner, and accordingly find them to be credible. I find that the evidence of the state witnesses to be satisfactory in all material respects. In my mind, the crisp and vexing question that needs to be answered are the following. 1. Did the accused act in self-defense at the time? 2. Did the deceased stab herself during the struggle between the parties as testified to by the accused? And 3. Did the accused intend for the deceased to die? It is clear in my mind that the plea of the accused is diametrically opposed to the version that he placed before this court. Although the accused's plea was one of self-defense, he testified that the deceased in the main stabbed herself. From this, it is clear that he did not perform any overt act of self-defense. This is clearly an anomaly that exists, which the defense has conceded to. The accused's version essentially is that during the course of an argument, the deceased attempted to stab him the first time, and he was able to disarm her. A short while later, she armed herself with a steak knife and attempted to stab him again. During the struggle, he was injured, and whilst trying to disarm her, she injured herself, which resulted in her dying. On both occasions, the accused applied significant force upon the hands of the deceased in order to disarm her. Dr. Marule testified that the deceased had only one wound and no other signs of physical injury. Further, that if there was a struggle as testified to by the accused, he would have observed bruising and injuries upon the wrists and hands of the deceased. The deceased did not have any bruising or defensive wounds on these areas, nor anywhere else on her body. I accordingly find that the objective evidence of Dr. Marule does not support the version of the accused regarding the struggle between the parties. Further, members of the South African Police Services who attended the scenes testified that they had not observed any signs of a struggle inside the flat. The next question that needs to be asked is, did the deceased stab herself or not? I find the answer to this vexing question in the following evidence that has been presented during the trial. Dr. Marule testified that a significant amount of force would have had to be applied in order to have penetrated deep into the thigh and totally severed the femoral vein and artery. That it is the innate nature of a human being to self-protect, and as such, in the absence of any allegation of suicide, the deceased would not have been able to inflict such a wound upon herself. Having due regard to the aforementioned evidence, I find that the deceased did not stab herself. I accordingly find that the accused had stabbed the deceased. The next question is, did the accused intend for the deceased to die? In this regard, the following evidence has been placed before this court for due appraisal and consideration. The accused, after seeing the deceased bleeding profusely on the floor, proceeded to tend to himself and then wiped the floor of the flat. He then placed the deceased on the bed whilst he continued wiping the flat and mopping up the blood. He advised her that he would take her to the hospital after he wiped up the blood. He then removed the bloody clothing and the knife and placed them in the motor vehicle of the deceased whilst she lay fatally injured in the flat. He then removed clean clothing from the spare room and packed same in the motor vehicle. The accused then sat down on the couch and made a telephone call to eNCA, where he informed her that he had killed the deceased. He then phoned the estranged husband of the deceased and informed him of the death of the deceased. The accused did not take the deceased to the hospital immediately for treatment, which was only 900 meters away. Dr. Marule testified that had the accused acted swiftly, the deceased would have been saved. I accordingly find from the aforementioned evidence that the accused clearly intended for the deceased to die. I further find that the accused cold-bloodedly stabbed the deceased during the course of the argument. As regards the evidence of Dr. Cooper, I am of the view that the objective facts clearly indicate that the accused had performed goal-orientated behavior, and reject the version that the accused was in a state of shock. From the totality of the evidence, it is clear that the accused full well knew as to what he was doing. The accused was clearly aware of what he was doing and what was happening on the basis of his actions, and more specifically, goal-orientated actions after the stabbing of the deceased. I find the telephonic admission to eNCA damning to the version and defense of the accused. Clearly, the evidence of Dr. Cooper does not take this matter any further. It is noteworthy to mention that the defense did not call Saki, nor the accused sister, who may have supported the version of the accused. If one is to accept that the accused had acted in self-defense on the day, one would have clearly expected him to have rushed the deceased to the hospital, summoned immediate assistance, approached the SAPS, showed them his alleged injury, and also remained on the scene to assist the police with the investigation. The accused did not perform any of these actions, but rather chose to wipe up the scene, removed items, and fled the scene. In addition, the accused eluded arrest for 9 days before he was arrested. These actions do not support any hint of innocence on the part of the accused. It is clear from the evidence that has been led that the deceased had allowed the accused to drive a motor vehicle previously. I am of the view that the state has not been able to prove the crime of theft of motor vehicle or the alternative of using motor vehicle without owner's consent against the accused. As regards count 3, I have appraised the evidence on this count and can conclude that the accused did not completely remove evidence from the scene, and as such, the state has not been able to prove that the accused had successfully defeated the ends of justice. However, the state has succeeded in proving that there was an attempt on the part of the accused to defeat or obstruct the ends of justice. I have accordingly looked at the merits and demerits of this matter. Coupled with the totality of the evidence before me, the reasonable inferences to be drawn from the totality of the evidence of the witnesses, the circumstantial evidence, and accordingly reject the version of the accused as being false beyond reasonable doubt. In conclusion, I find that on a consideration of the totality of the evidence, the prosecution has discharged the onus to prove beyond reasonable doubt that the accused has committed the crime of murder and an attempt to defeat the ends of justice. On the other hand, the version of the accused is rejected as beyond false. You may stand, Mr. Donald Sebolai. Mr. Vusumuzi Donald Sebolai, in the result, you are found guilty and convicted of count 1, murder, count 3, attempting to obstruct or defeat the ends of justice. You are hereby acquitted on count 2. Do you understand? Thank you. That being the judgment of the court, Madam Counsel.
At this stage of the proceedings, the counsel for the defense and counsel for the state have to arrange a date for postponement for the sentence. It has, however, not been done, and we will have to discuss the request that we quickly adjourn just to arrange a proper date. And if the court will just indulge us with a few minutes.
Thank you. The court will then take a short adjournment in order to enable counsel for the state and counsel for the defense to arrange a date for sentence and for other preliminary procedures that they may decide to embark upon. Thank you.